We will be finishing testimony with Lieutenant Brian Tolley, Ryan Gallerani, Nicholas Bradford, Tess Chart, and Andra Porto. Back to the channel, my beautiful, intelligent viewers. Today is review of trial day 24. Lieutenant Tolley back on the stand today. We find out that he didn't search the 34 Fairview home because, as he states, quote, "We had no reason to believe that the evidence found within the home of 34 Fairview Road," end quote. Are you confused with what I just quoted? So am I, because that made no sense. That was what he responded with. So what was that? I don't know what kind of answer that was, but no one questioned him about it. And if you weren't paying attention, let me reread that quote again. Quote, "We had no reason to believe that the evidence found within the home of 34 Fairview Road." That's what it was. That's why he didn't, that's why that is the reason why they had no reason to search the home of 34 Fairview. What he should have just said, which would have been more truthful, is like Michael Proctor said, "We already knew who killed John. There was no need to look at inside of 34 Fairview." Like, let's just be real here. That would have been a more realistic answer than that. After more questions about the search, he said he didn't believe Mr. O'Keefe entered the home. What did he base that off of? Who knows? He didn't have an answer for that. Yeah, that was it. He had no reason to believe it. Never mind the fact that John had been invited into that home that night. And that's where John was, dropped off. The fact that he even is on the property can tell the normal human being who's not trying to hide something, that person probably went into the home if they were invited there, and now we're finding them dead on the lawn. Hey, maybe they didn't make it into the home. Who knows? But we do know he was invited there, and he is now on the property. Not just on the property, he's on the property dead. No reason to look for any evidence in the home. Let's keep going, people. Let's keep going. Just digging further through their pile of shit. He said that he only had evidence that he was outside and not in the home. Oh my gosh. I can't even keep a straight face while reading this stuff to you guys today. This is like, usually I can kind of suppress my laugh, but that is the silliest fucking response. This is like another I can't moment. And you based this, what, because you found John dead outside? So that's, you're gonna just assume he died outside? Never mind the fact that he was invited into this home. But hey, we'll just say, hey, we found him dead outside, so that tells us he was never in the home. So we'll just wrap it up from there. No need to bother investigating any further. This is where he was dead. This is where he was found, and so that's where he died, and that's as far as he made it. Stupid. I don't know if I'm just short-tempered today because of all of Lowley's continued throat clearing. I'm gonna play a short clip how much this disgusting man clears his throat.
And get to that a little bit more in a moment, but as far as reason to believe that that Ms. Reed's vehicle was traveling in the area around those times, what, if any, information did you have to base that on?
We had statements.
Now, with reference to the Temple video, what, if any, information did you receive in regard to the timestamp on that video?
That was also accurate.
Now, from each of these respective locations.
Imagine listening to that for 7 hours a day. What day are we on? For 24 days already. I've had to listen to that disgusting, gross cough. Ugh, so gross. I don't know if someone hasn't just like jumped up and like ran out of the courts, like throwing up at this point. Let's just keep going. Mr. Jackson referenced Mr. Tolley's testimony from earlier and pointed out that Mr. Tolley does not need a search warrant to enter a home. So the reason why this was talked about was because he's saying there wasn't enough evidence to go ask a judge for a warrant to search the Albert home. However, he doesn't need evidence to search a home or anything, a device, a car, whatever, if the person says, yes, you can search it. Did he ask the Alberts at any point without even bothering to get a warrant? Did he go and ask like, hey, do you mind if we look around your house? No, he said no. he didn't bother to do that. Would he have gotten in trouble if he tried getting a search warrant from a judge and the judge looked at the information and said, no, I can't authorize a search warrant. There's just not enough information here. No, he wouldn't have got in trouble for that. It would have just been denied. Did he attempt to do that? No, didn't bother to do that either. Why? Why bother? No need. Cut and dry case. Bag 'em and tag 'em is what I like to say. That's basically what he has done. Mr. Jackson asked him if Mr. Tully was aware that John had actually been invited to the house of 34 Fairview, and he said yes, he knew that. To Mr. Tully's defense, he doesn't believe he ever went into the home. What he based that off of, who knows? Well, clearly not fucking evidence. He just based it off like, there's the body. That's where he died. He never moved from that position from the time he was dropped off. Holy cow. And you know what's sad to say is I'm sure this is done all over the country.
Not only is Karen fucked, we're all fucked here.
Okay. The next thing I have, I'm actually really confused with, and I need one of you guys to help me with this. Mr. Jackson had stated that John was found without a coat on in this 18-degree weather. However, I'm confused because this coat situation, I'm not sure where this coat is coming from. I remember at one point, like maybe in trial day 2 or 3 or something, they had interviewed one of the first responders. One of the paramedics said that they cut the coat off of John. And I remember him being questioned and said, like, did you cut the coat off him? And he said, no, he didn't cut the coat off. And he said, well, who cut it off? And he said, I don't know. It was already cut off. I haven't seen any evidence of even a cut coat being presented. So I'm really confused if there was even a coat, because I also remember them stating within that 3 or something that John wasn't wearing a coat. The only thing we've seen is just him using that pullover. I'm not quite sure how this plays into this, so I need your help to help me clarify that for me. Mr. Jackson asked Mr. Tully if it would be reasonable to say that if an individual was found 30 feet from a home they were invited into and doesn't have a coat on, that maybe it's because they took their coat off while inside of the home. And Lieutenant Tully said, no, that's not a reasonable, it's not a reasonable thing to say. Tully was also asked if he was aware that Michael Proctor and Mr. Buchanan both initially believed that John's death could have been from a physical altercation, which they both stated at different times within reports. And Mr. Tully said, yes, he was aware of their initial beliefs. And he further agreed that an individual's shoe could come off. Potentially, yes, a shoe could come off if an individual was being dragged. Witness came forward at one point and said they saw a Ford Edge in front of the Alberts home at around 2:30 a.m. where John's body was actually found. Who actually owned a Ford Edge in this specific time at this specific location was the Alberts. They did own a Ford Edge at this time. Mr. Tully said that after several investigations or several interviews of this witness, that supposedly they changed their story and they didn't feel it was credible at that point. So his story went from they saw the vehicle there from Cedar Crest Road, which was some distance away, in a blizzard, as Tully pointed out. Then the person reported that they were colorblind and was operating a larger motorized vehicle. What their vehicle size has to do with anything of credibility, I don't know, because I don't see a reason to discredit a witness because it's snowing and they're in a larger vehicle. Am I missing something? And the person reported that they were colorblind and operating a larger motorized vehicle. What their vehicle size and their colorblindness had to do with the validity of their statement, I don't know. Trooper Tully doesn't give us any explanation for why he invalidated their statements because of that. It's not like he said it was this specific color. He's in a larger vehicle, what? So then if you're in a smaller vehicle, you're credible? Like what? In the third interview, saying that when he had arrived, the Canton Police Department had already had the street blocked off around 4 a.m., which places the Ford Edge outside of 34 Fairview at the time before that. And they know that the police did not arrive at 34 Fairview until after 6 a.m. This is all Mr. Tully's explanation on why they discredited this individual's statements. And then goes on to say that Trooper Michael Proctor interviewed this witness and went outside in a parking lot and told this witness, is that the vehicle that you saw? And he said yes. He said he wouldn't do that as a police officer because he wouldn't give a witness one picture or one thing to look at to identify because it's suggestive, and then the witness starts adopting that description to whatever it is that they're describing. So, okay, so you're telling me that Michael Proctor, the lead investigator of this whole case, didn't do what he's trained to do, which is show more than one item. So what you're telling me, Lieutenant Tully, if you're colorblind, you are not a credible witness, even though color had nothing to do with this individual's statement. You're also telling me that if you drive a larger vehicle, you are not credible. So since your investigator, Michael Proctor, was the one that showed this individual one single item, they're now not a credible witness. So then you guys fucked up this witness. You guys fucked up their testimony. You guys fucked up their credibility, not the individual. That was the end of cross-examination with Mr. Tully. And next on the stand is Ryan Gallerani. Ryan Gallerani is a sergeant for, please forgive me for where he's the sergeant. I played this over and over again trying to understand what he said, and the best I could hear was Nadiv Police Department. I don't know if that's a real place, but we're just going to go with that. So that he's a sergeant for that police department. He said he was the individual who swabbed the inside of Michael Proctor and Sergeant Yuri Buchanan's cheeks to collect DNA to be tested. And that was the end of his testimony. There was no cross-examination from defense. Next on the stand was Nicholas Bradford, and he is the DNA analysis for Bodie Technology. This is the guy who DNA tested the extract from the hair from outside of Karen's SUV. And he compared it against Michael Proctor's DNA and Yuri Buchanan's DNA. Don't get that confused with thinking he was the one that did the extract from the hair. He was not. He was just the one who tested the extracted information that was sent to him against Michael and Yuri's DNA. He also did a profile on the DNA from the passenger tail light from Karen's SUV, and he was able to determine it was a mixture of 3 individuals, including 1 male. He said that the DNA tested shows strong inclusion of John O'Keefe's DNA and exclusion of individuals who could be related to John O'Keefe, as well as strong exclusion for Michael and Yuri's DNA. That was only for the tail light. The hair actually was determined by him not to be usable, and he said it's because it's a hit or miss. Since they received it already extracted from the hair, he said that they didn't think it would be able to work for nuclear STR testing, but they decided to go ahead and test it anyways, even though it's a hit or miss. And he said that as they had figured, it wasn't useful, so they weren't able to conclude anything with that. He said that they are usually able to get more DNA out of a hair follicle than just a piece of hair. So you would need like the root of the hair to get that DNA, because that's where the DNA would have been found within that hair. There was no cross-examination from defense for this witness either. Next on the stand is Tess Chart, spelled Tess. She is a forensics DNA analysis, and she continued to test the hair and compare it with a sample provided from, but they took the hair from John's body. And she explained that sometimes there isn't enough nuclear or abdominal DNA. She said you can go back and try and test for mitochondrial DNA. And this is a second kind of DNA, which is different from what you may be thinking of like the DNA where you get half from your mother, half from your father. And she said the sample she tested was from a piece of a swab, and she tested it and then put that information into a national data bank, which helped exclude John's DNA from anyone who is African American, U.S. Caucasian, and U.S. Hispanic. So whoever's DNA that was on this swab was not anybody who was of African American descent, U.S. Caucasian, and or U.S. Hispanic. That's all we got. There was no cross-examination from defense, so we are going to go ahead and move on to Andra Porto. He is also a forensic DNA tester. He gave testimony that was almost identical to Miss Chart's testimony, that he talked about the stain on the upper part of John's pants and the glass from the drinking cup were found more likely from John and 3 related individuals than from 3 unrelated individuals. And there was no cross-examination, so that was the end of Mr. Porto's questioning, and that was actually the end of trial day 24. With that, I thank you so much for watching and paying close attention. I look forward to hearing your questions or comments. Don't forget to like, share, and subscribe. I will see you next for trial day 25. Have a good night.